A very good afternoon to all our esteemed participants attending this 17th webinar of ICSI Master Knowledge Series EEE. I am CS Rakesh Kumar, Assistant Director ICSI, and it is my privilege and honor to host this webinar on behalf of ICSI and welcome you all at this webinar. Friends, this Master Knowledge webinar series is an initiative of ICSI to disseminate and share expert knowledge with our professional colleagues on various topics of professional interest under the Companies Act, SEBI regulations, and various other corporate laws. This webinar series is aimed to create better understanding of legal provisions and practical aspects involved while complying with the legal provisions. It is through these initiatives of ICSI we keep ourselves updated on emerging areas and sharpen our skills that builds our confidence to grab the professional opportunities available in the market. We have received overwhelming response from our professional friends so far, and it is with your active participation that we were able to successfully organize 16 webinars so far under this series. And now we are moving ahead with this 17th webinar of this ongoing series. I assure you that many more webinars are planned in the pipeline, and we hope to receive similar support and your continued support for all these webinars, including today's one. Friends, the topic for today's webinar is very apt and relevant. That is fundraising by companies. As we all are aware that the funds are very important for any functioning or proper functioning of the organization. The companies need to grow and invest in product development, research areas to remain relevant and sustain in the market, to remain competitive and to sell their product better than their competitors. So they actually need funds for the growth and to meet the requirements of stakeholders. Be it individual or a corporate entity, one has to invest more money to make regular funds as per the needs of the day and also to provide better return to the stakeholders. That is why that every company has to raise fund at some point of time to develop new products and expand into new markets. The funds may be raised from internal as well as external sources. It depends upon the suitability and the requirement of the organizations. There are various sources to raise fund like debt, long-term, short-term, equity, preference share. We all will deliberate on these with our expert faculty for today's session. The company need to analyze and opt for the optimal source of fund considering their interest and in the best interest of the stakeholders. It also depends on the goodwill of the promoters and the market value of the company, which facilitate the corporate to raise fund easily from the market, particularly the financial institutions. Now it is the time to welcome our eminent speaker for today's session, CS B. Ranganathan, who is a well-known professional and a corporate law advisor. His earlier stint were with Amcor Pharmaceuticals, Edelweiss Financial Services Limited, and the Tata Group. He is a fellow member of ICSI, CMA Institute, and a lawyer. He has 33 years of experience in the corporate field, encompassing governance, company law, investment banking, corporate restructuring, NBFC, and allied corporate law matters. He was a member of the expert group on sectoral standard of ICSI. He was a member of the Company Law Review Committee constituted by MTA to review Companies Act 2013. He is a senior faculty with various business schools and professional institutions, beside being attached to industry association, and has delivered sessions across India and abroad. We welcome you, sir. And we request you to kindly enlighten our participants about the various aspects of fundraising by companies and also the important role played by company secretaries during the process of fundraising. Before we actually start the session, it is my duty to request our participants to actively engage in this webinar by asking relevant questions in the chat box on the subject, and those queries will be taken with our expert speaker at the end of the session. Over to you, Ranganathan, sir.
So good afternoon, friends, and good afternoon, Rakesh. Nice to see you, Rakesh.
Good afternoon, sir.
Good afternoon. So season's greetings to each one of our fellow member friends. So all the best to you in your endeavors, whatever we have to do for the next coming year. So all the best. And so with that small note, thanks to ICSI for also calling me as a speaker to be in front of you virtually. Fine. So I think Rakesh has set the tone. It's a very nice of our the institute's management also to Rakesh is also is a member, is our fellow member, and there are many more company secretaries within ICSI. I had have a lot of opportunity to interact with them, so we need to respect them, and we need to encourage them to come and do such kind of things. Thanks, Rakesh, on behalf of all your colleagues. I convey this, I take this opportunity because I know the pains that you people are doing, undergoing, so very good, thanks for this initiative of ICSI too. Okay, good that Rakesh, aaj rakha instead of yesterday, and nobody would have come, so luckily it is here. Okay. Now, friends, I think Rakesh actually started the session saying that there are different avenues available for fundraising, etc., etc. That's fine. That's fine, But we, as one of the thing that I would always reiterate in any of the forums or even in personal meetings is that, friends, let we guys as company secretaries have confidence in us and in the profession, to first, let's have that confidence. Secondly, also believe that we are the best interpreter of corporate laws, friends. I think I firmly believe in that, and including the principles of company law. Let's not forget that, so I think we are the best guys. Now, how do we take that journey? How do we take that is what I think. If we understand and if we have that self-belief, I think please venture out into capital markets too. You might be trading, you might be earning crores of money, that's different. But as a professional, fraternity, I feel, there are many miles to go. The path is very wide enough, and I think we have to venture and say it, friends. And then you will understand the beauty of this profession. It doesn't come overnight. And the beauty of, and we are the best guys to participate in the capital market activities, friends. So with that note, friends, let's have, building that confidence within us and slowly venture into that. Hopefully to see many of them, because in most of the seminars and webinars, I find when there is something on the listed space, except LODR, nobody comes. But that's not the case. I think we are the best guys. Who else in the entire chain of entire team? I think in an IPO team, if you see in an IPO team, the bulk of the things that is being done by the company secretary, whether inside or PCS comes and helps, bulk of the things are done by him, which ultimately, if we have to have the credit, we should also be technically sound enough to justify, our stand, friends. I think that's where things are there. We have got a lot of opportunities. If time permits, I just wanted to take you through not only the IPO thing, but what are the other spaces? For example, AF, alternative investment funds. What's the role that you and I can play? InvITs, REITs, and the social stock exchange, the new concept that has come. So broadly, if Rakesh allows me, briefly, whenever I will just touch upon all those things. But there are plenty of opportunities, is what I'm trying to say, friends. So with that positive note, let's start our thing. So, and some of you who would have, listened or attended my session, I'm not a PPT guy, but since it's a virtual mode, I have to depend on it. But my flow will be in my own way, friends. Please, Rakesh and everybody, you need to just to, I know that's a disclaimer which I just wanted to place. Secondly, the other disclaimer is I'll be touching mostly on the very basic thing, friends. I think what we are, one of the things is what is primary important is that, we all have to be more of Rahul Dravids, where we should be the wall, and I believe in that. I firmly believe in it. And that's the reason we are two good people. Please, let's also exhibit that caliber. Okay. So with that note, with that small yarn, let me share my screen. So Rakesh, I'll just start sharing my screen, and if at all any help needed, the tech team can support.
Yes, sir.
Okay. So I'm fully audible, right, Rakesh?
Yes, sir. Yes, sir. Very much. Okay. I think in the past, if you see the last few years, always there is a saying in the financial services, especially in the capital markets, it's a 7-year cycle that happens,
So I think this is the boom period that we are witnessing, at least from mid of 2022 till date. And in fact, in 23-24, just to tell you a small statistics, there were around 38 issues which got listed, 38 companies that got listed for around 33,000 crores, and for 22-23 it was 37 entities and 52,000 crores were mobilized through the IPO route on the main board. As far as SMEs were concerned, last year was 114 with 3,200 crores, and the earlier to that was 125 companies with 2,200 crores. But along with IPO, this is not the only way to raise funds, but along with IPO for listed companies, there is something called QIP, which we all know, what do you call the qualified institutional placement? I think even in terms of raising the funds through that method is also a very easy process, and lot of you can see a lot of deals happening on that front as well. Of course, preferential allotment, a lot of statistics may not be available. That also happens, but QIP and IPO are some of the two things. Of course, SME is also one of the things that it has picked up, friends. Okay, now I think we all know, friends, that let's take a small example and then let's take the journey forward. Today, before we get into IPO, we are an unlisted company. We need to prepare ourselves, get ready for the ultimate show, which can happen, say, for example, 12 months to 18 months. So what are the different things that you and I have to play? What is that we need to tell the management? And how do we go forward is the first thing that we all have to do, friends. So first and foremost is, whenever the management conceptualizes an idea of, what to raise and how much money is needed for a particular project, I think that's the funda of anything. So there are different ways, as Rakesh said. I can go to a debt and raise money from a normal bank, right? Instead of that, why do it? There are advantages of getting into a listed space. Okay, so and that's the reason we plan it in advance and go ahead with that. So first and foremost is what you do. You just take the concurrence of the management. You take the concurrence of the board for that with a broad idea, instead of having a correct figure which could be corrected later. You just have a broad idea about what is going to be the thing. Because of late, if you see, friends, a lot of family concerns, family, firms, what I would call family firms, they were all, trying to raise money for on the primary side. But in all probability, it starts from 2005 and 6. India has been witnessing a guy who comes much before the entity goes in for list, who is called as a private equity player, who comes in between and much before the show happens. So the role that a private equity plays is, though he is not called really as a strategic investor, but the amount of the importance that he gives and the amount of the efforts that he puts in to see this company grows is something one has to acknowledge or not. But at the same time, one of the ways of the private equity getting exit from the company is through the IPO route, and that is another. So of late, if you see, we all know, friends, that there are two ways. One, a primary issue that happens, as well as second, an offer for sale that can happen, which is basically a secondary transaction, but getting listed on the exchanges, or a combo of both. So of late, if you see, a lot of offer for sale have been happening, but more of a combo of primary issue and more of what you call offer for sale, because naturally the private equity people want to get out of it. So these are the broad. But my only, again, friends, my request is, always whenever we take any project, whenever, say, for example, in this case, the fundraising, now IPO, friends, you need to excuse me, as I said, I may refer to the PPT or not, so please. And that's one way of making you listen, otherwise, because naturally, the private. Okay, so one of the thing is, where did I? So when a company, conceptualizes the idea, that's the stage where you and I have to. So first, when you take a project, friends, please, very coolly take your time, maybe a day or two, just analyze what are all the different regulations and the acts that are applicable. That's the first thing which you should know. Second, don't forget Companies Act, friends. I think the mother of all corporate laws is the Companies Act. So lay down. Now today we are talking about SEBI, through ICDR is, administering the entire chain of events in an IPO process, right? Now, where does SEBI get its power? Everybody will say it's a SEBI Act, but where does the SEBI Act come? It's basically emanating from the Companies Act, friends. Section 24 talks about giving that power to them. Earlier in 56 Act, it was Section 55A. Okay, so that's the first and foremost thing which we guys have to first. Where is it said in the Companies Act? So first let's understand why I'm telling you, friends, is many a time when we speak to our own friends, our fraternity, they would have done a lot of things in an IPO. They would have done, and when something is being asked, a very simple thing, what is the eligibility criteria, under which regulation did you fall, 6.1 or 6.2? The answer is blank. I witnessed. It cannot happen, friends. Second thing, please, we are the custody of all the records, corporate records. So right from, I think the basic thing is on the minutes. While the advocates, the law firm, the counsels will give you a lot of things, compiled version of what are the standard resolutions to be passed. Please take some time to go through that, friends. Or else you draft it. You draft it and see what else you can add value in that. You draft it. I think the way we can draft is far, far superior than anybody else. I think have that confidence, friends. Recently, I happened to do some, some of the preferential allotment, some resolutions and explanatory statement that came to me. It was, drafted like an agreement rather than a notice and an explanatory statement. So please, friends, first and foremost, let's take that initiative of drafting. I think I want to emphasize this. Always I have been emphasizing on drafting, so please do that and don't depend only on that. So first read that. What is essential is, so it's been the talk of the town and we know how it is. So capital markets, again, primary and the secondary market, and especially when it comes to, in this journey of unlisted company going and doing it, what are the different things? Now, assuming that we start the role today, we as a CS IPO journey, this is something about 21, 22, 22 I touched upon, but this is of 21. We will also see some of the small things. But just before even getting into thing, I like to spend 2 minutes. I'll take this opportunity, we as CS fraternity should also know, whenever you take any incident, friends, there is a history, or there are some corporate accidents that would have happened for regulators to come and, because law is evolving each and every day, right? Every day. It's not something which is static. So, and it all depends on practically how the companies are doing and certain incidents that happen based on which. So we also need to know slightly on what has been the journey of much before, a couple of things which I just wanted to tell friends. Don't forget 1970 if you are talking about capital markets in India. Don't forget 1970, 1980s also. 70s, there is a concept called Ferrar dilution, friends. What typically happened during that first time when Janata Party came to power is that there was this minister called George Fernandez. He introduced a very beautiful concept called Ferrar dilution, meaning all the foreign wholly owned subsidiaries in India, foreign subsidiaries cannot hold more than 51% or 40%, depending on, there are two categories, in India, and they have to, where will they go? They will have to offload it to the Indian public. That's where the first, the momentum to the entire capital markets started in the 1970s. It's called Ferrar dilution. And then 1980 belongs only to one man, Dhirubhai. So I think we all vote to him when we talk about the capital markets and keep on talking about the capital markets and his journey and whatever the innovations that you and I are, party to it today. But way back he has done, and he has shown India what all the different types of instruments that could be issued and how the market could be propelled. And that's how the 80s belong to only one man. and come, and that's where, where everybody was, the government was thinking that it should be separately controlled, and that's why SEBI came into being, and CCI, the controller of capital issues, was abolished, and SEBI took over in 1992. Now, again, we should also know the journey of the SEBI, friends. 1992 to 2000, in fact, the entire IPO and the preferential allotment, name, bonus, shares, everything was governed by way of notifications. I still remember there were 22 notifications still, so anybody could have challenged, because SEBI was also new. It was coming up with so many things, and we saw a lot of scams happening in between, not only the other scam, but there was one very famous scam, I know, particularly on the capital markets, if you can go and refer, MS shoe scandal, which happened sometime in 94, 95. So all those things led to, a complete revamp, and then it was formed, and then the notifications were made guidelines sometime in January 2000. But that guidelines introduced very beautiful concepts, friends. One of the beautiful concept, two things I would really, even today, it is still, we are following that is, one is the book building process. The second one being the categories of investors. Maybe the proportion would have changed now, but these are the two main things that had happened during the initial, when what you used to call as disclosure of investor protection guidelines. So that was also in way till August 26, 2009, when all these guidelines became a regulatory part of it, and today we are calling it as a regulations. Again, the 2009 regulations have undergone tremendous change in 2018, and come November 2022, a new concept of the processes also, which is called the confidential filing of the document as also. So that's how the journey, one should know. In between 2006 is also very paramount important, friends, as if you're part of the capital markets and doing, that's also very important in the sense, Rakesh, you were talking about debts, during the initial phase of 2002 to 2007, people were rushing, going out of the country to borrow money through ECBs. And one of the mode was, the ECB, direct ECB, and the second one was FCCB, where, people were going and trying. And that's where the government realized, and they came out with, why do you want to go out and do this? Because in that case, there was a foreign exchange, the fluctuations have to be borne by the company. All those stuff was there. And that's why we had, the SEBI had introduced a concept of qualified institutional placement. Why should you go there, boss? You people are here in India, because already FIIs were, dominating the market. So why you guys better invest in India? And that's where the QIP. So everything, friends, has its own small story, which I would believe we all have to read at least, at least read once, whether you remember or not. But please read, friends. Even for buyback, there has been a incident. Otherwise, under Section 77 earlier. So that's the background which we all have to know, friends. Now I'm an unlisted company. I want to raise funds, through an IPO mode. What are the different things we as company secretaries, what we should do? Don't classify as PCS or employment, friends. It is together. I think a lot of PCS, I'm very happy that, a lot of PCS are now getting into the due diligence aspects of an IPO, which is a very SEBI was the free pricing, friends, from what it was a controlled regime where the price, for a listed entity, control of capital issues was fixing a price for a particular issue, and the price could not go beyond that. I'm an entrepreneur, but somebody else is fixing my. But even today, that CCA formula, friends, whenever even though please have a look at that CCA formula, which a lot of valuation experts even today they refer to how that formula was arrived at. Okay, now primary and secondary. Before getting into that, friends, let's look at the Companies Act. Now, the chapter 3 is entirely devoted for fundraising. I would put it that way because it has IPO, it has private placement. Okay, you may say 62 may be ahead. That's one of the things, I mean, in terms of the process. But first, let's understand the variable, the main sections. There are some sections which I had just left it, 23 to 42 is the main one. As I said, 23 talks about how you can do, what are the modes of doing it. Now what's a major change that has come on October 30th? I think I have a slide, but never mind. But that talks about Indian companies going abroad and getting it listed directly, even without getting listed on the Indian exchanges. That's a great, in one of the budgets it was announced, but I think in 2022 budget, but at the same time, nothing had happened. So now there is a notification. So 23 subsection 3 gives you that eminent power to go and do this, but of late, I mean, the only thing as we speak now, only you can go and list in the gift city as of now. Later on, the government will notify which are all the countries where you can go and list your equity shares. But there are a lot of advantages, some very few, I mean, good advantages that I can go and raise money from abroad. That's the biggest advantage. But we also need to look at the process overseas as to how the local regulators will administer this entire. Otherwise, we had only ADRs and GDRs till now. So this is a welcome move, and we need to be geared up for such kind of events that might come. All of a sudden, you also know your clients are up to do that. Of course, laws also will change. The Companies Act to change a bit, and the ICDR also will have to give leeway for all these things. But yes, it is in the anvil, and so please, friends, let us be prepared even to go and get our right. So at least let's do that kind of analysis of what are the different things, and what is the impact on FEMA रहेगा. Because friends, again, I would take a small 30 seconds here to tell you, all these things. Do you think it was not really tested? Yes, it was tested. Go and look at the what do you call the Bharti Mittal's Sunil Bharti Mittal's proposed acquisition of MTN of South Africa way back in 2008 and 9. Both were failed attempts, but it taught the entire Indian legal fraternity and the government what are all the things that could be done. So that was the greatest thing. And even only one thing, what typically happened was the fully convertibility of the Indian thing was full capital convertibility was an issue at that point in time. So one doesn't know how those things are going to be addressed. But yes, it is on the anvil. Let us be prepared is what I just wanted to upfront say, this listing abroad. Okay, so that's one thing. So secondly, in terms of the entire, I think we all, many of us friends, typically even today, first of all, go and read what is a listed entity. Is it defined in the Companies Act? So first go and see what is there, or how 252 or 251 or how does it define the company, the listed entity is the first thing that you and I should know. Prospectus, today when you speak about prospectus, everything earlier it was in Schedule 2 to the 56 Act, but now everything is governed by the ICDR, ICDR provisions. Offer for sale, many of us might be wondering, where does this come from? Why do you have to take approvals? But yes, it was very much as a part of the Companies Act, both in 1956 and here in the 56, it was in Section 64. And, so these are the different things. Also, don't forget, friends, this is one of the things which, Section 37, which talks about class action suits. Okay, so any guy, and of course, more than 10% together, can sue the issuer about whenever there are some misstatements in prospectus or if there is any fraud committed. But, so be aware of that provision as well. And the allotment of securities I've mentioned, again, please go, though it has been, you need to follow the, what do you call as the ICDR provisions. but have a look at it. Private placement, of course, section 42, we all know what is the intention behind this. Why there is a separate a section for private placement. We all know earlier in 67 subsection 3, there was only one subsection which talked about entire thing. But now today you have a lot of things in private placement, friends, thanks to whatever the incidents have happened. But now slowly let's get into the diligence mode as well. This, let me see, Badme. First, what is the due diligence process that you and I should really look into? First, as Rakesh also said, the background of the promoters is also very vital, right? He started on that note. Now, first, friends, normally, we end up, throughout the year, we end up in finding out, who is the correct promoter, who should belong to the promoter group. There is a clear-cut definition. Please compare it with the ICDR and, of course, our Companies Act. It's almost the same. Also look into what it's only typically restricted for the purpose of IPO, friends. So you need to just, rely on the Companies Act definition and as well as on the. So first go and find out what is the promoter and promoter group. Second thing is, the group companies. Now, group companies, Companies Act doesn't define, right? So, but group companies, you find it in ICDR. So find out what are all the group companies, because again, all the disclosures relating to that would also come as. And again, there is something called material companies whose entire financials have to be disclosed in the offer document. So there is one thing, what is that materiality? How do we determine that? What are all the things that I think that's the role that we can always play, friends. And why I'm saying, emphasizing on this point is also one of the things which, if you see, I've talked about updated minutes, and that's okay, updated minutes. But even writing the minutes very clearly about IPO is not something which you pass a resolution under 179 and 62. Once mein pass kiya, kaam khatam. No, friends. There are n number of things that, that's what I started this session saying, that if you have the confidence, I think a lot of things could be done by us, and very effectively and very clearly we could do the things. So just on the, why I'm talking about the promoter companies, friends. What happens is typically in certain kind of organizations, whenever there are two sets of shareholders or three sets of shareholders, somebody would have been named as a promoter. But come at the time of IPO, they just want to get dissociated with that existing promoter, and they don't want to call themselves as promoters. Be careful of that. So first and foremost is we need to be very clear as to if it goes, then, because a promoter is a guy who has been named in the offer document also, right? So let us be very clear as to, secondly, you might be having a lot of relatives or a lot of, the close relatives and which are coming under the definition of the relatives. But suddenly there could have been a lot of, dispute among the family members and other things. If that being the case, please collect the documents, the separation agreement or whatever the backups. Why I'm emphasizing on all these friends is, I think these are all the things where you and I have to, let's not rely only on the counsels or the so-called law firms. I'm saying they are doing a wonderful job, no doubt. But at the same time, I think we are the custodians. I think we should give them that comfort. Yes, if we guys are there, the law firms should get a great comfort. I think that's where our role also comes in. So the classification of promoter and promoter group determined in advance, because now other thing is one who has been named in the one who has been identified in the annual return, right? So please be mindful of all these things before we do it. And then, of course, KMP and SMP has again now ICDR may, it's more or less similar to what is there in LODR regulation 16. So that is one thing. Also, we all know all the public limited companies have to get issue shares and only in demat mode right from October 2018 or 19. I forgot the year, but so ensure that all your promoters holdings, because this is another major area where I feel that most of the promoters shareholding should is not getting dematerialized. And so don't wait for all those things, friends. I think proactively we should start. That's why I said first go and get at least the headings of the applicable regulations or the sections. You will know once you read that, then, because, for example, the lock-in provisions, all those things come at a later stage. Okay. And but before that, what are the different things that are required is very, very important, friends. Objects of the issue, I will come later. The litigations. This is one area where I think we all have to be very, very careful of, because you need to collate whatever the entire litigations today. In Indian context, you don't have a pan-India presence of all the cases coming, and at the click of a button, you can find out all the cases. So litigations right from the beginning, put all the efforts and try to dig out what are all the different litigations that have come up. And then once all the litigations, the regulations also doesn't require you to disclose each and every litigation, but yes, we can set a materiality threshold in consultation with the merchant bankers. We can set out, because what is the practice that is prevailing, what's the regulator expects, based on the same, we can have a materiality threshold. Again, litigation from, I can quote a small incident for 30 seconds. Way back in 2007, there was a very good real estate company which is doing very well even today. The issue opened on the first day, and at the time the emails, though it was all in vogue, but at the same time people were using fax mechanism to send out a lot of things. So 2007 November. This guy on day one of the public issue, he sends out a fax to SEBI saying that, boss, you have not included my litigation in this. Okay. Now, suddenly, immediately SEBI said, please issue a public notice, and whoever has, if they are wanting, give an option to them, whoever has subscribed on day one to get a refund of that amount. But did not happen. The issue went to. But what I'm saying is, finally it turned out to be that out of they had disclosed almost around 94% of the litigations that were. 94% is too huge a sum. This one particular thing did not even had any material impact on this entire issue. So let's be careful. We need to teach. We need to guide our the legal team. If you are not part of the legal team, please tell them this is what is required. And yes, materiality threshold. Now, why I'm emphasizing on materiality threshold, friends, is that when you do the resolutions, when you pass the board resolutions for each and everything before you file the DRHP with SEBI, friends, each and every part of it has to be in the form of a resolution. That's the correct way to do. If we have to guide, and that's the correct way to do. Don't say that DRHP, usme sab cheez aa gaya, so it is not that way. It's not that way, please. The materiality threshold, because tomorrow the regulators, everybody, who is the deciding authority? You can't say just because DRHP has been approved, it's the board. But please be careful on setting the material threshold. Let the board give that, let the board decide as to what is the materiality threshold. Then comes, again, one more thing is many companies will have a lot of cases which are not important, or a lot of 138 cases. What regulator is asking us to do is just to put the number of cases, and if at all there is a value to attach, only the number we need to. So that is also a very, very crucial thing, friends. Very crucial thing that is required to be done. Capital built up. This is entirely, I think each and everybody depends on us, friends. The capital built up, So today, what's happening? Even for unlisted companies, there is this reconciliation of capital audit that's been there. It was only for the listed entities. Now today you have everything capital built up, especially for companies which are more than say 15, 20 years old. Many a time we say that, boss, kidhar se leke aao? Please, I think there are different ways in which you can get it. But it's for you and me to sit and see how best we can. Many a time it may not be possible. So the two things, what is happening? Sometimes when you don't get the records, you do a public search. Public search may you get mostly you get the data for the last 10 years, or maybe, if you're lucky enough, you get even from 2006. And milta bhi nahi hai wo. Okay, that's okay. But whatever is that, you should put in an efforts to go and do that search, friends. And some of the ROCs have this small practice, that to say that this public inspection, we do not have such kind of records, because under the, what do you call, destruction of records rules, they would have destroyed. Okay. So if you get some sort of a letter from the ROC, that will also have a good stand. But when you do all these things, there is always a risk factor that comes in. If you look at most of the, what do you call, the DRHPs of this in the last maybe 3-4 years, if you see, you will definitely have one risk factor which is pertaining to the company's records, company secretarial records, company law records, friends. So there is a standard risk factor that's given that, especially when you have already been subjected to any investigation or inspection, then all the more, or compounding, which if you have done, then there is a risk factor that goes to say that the company has done this. However, the company, though it is presently everything is sorted out, but there is no assurance that the company will be in a position to comply with, because it's completely reflects on the, so please, this is one area where capital built up is something which you and I have to take it at, and see. Approvals and licenses, yes, many a time you and I might be handling along with the other colleagues in the team. So, so depending on that, the approvals and whichever license is pending, I think we should be upfront. What regulator says, it says that even if you have applied for a license, please mention it. That's the thing, because the entire thing, if you are subjected to running the business based on these approvals and the license, I think that's the base, right? And that's the reason. This is also, I'm just putting each and everything, friend. This is the area where we have to full do it. Then the material agreements or the contracts, what you call, there may be a lot of the business agreement is one, whether it is vital or not, one has to decide. But if there are shareholders agreements, so typically those things will form part of, will form part of the material agreements, which you may have to undergo, which you will have to thoroughly see and friends. So don't ignore those material agreements. Now, especially when you have shareholders agreements, and the articles, and the articles of association, also, please always look into the articles of association, at least once in a year, please let's take it a point to refer at least during the AGM or the general meeting time, So, but even come IPOs, in the case of an IPO too, please refer to the articles of association if it is required to be modified immediately after, during the course of this, So just to see whether it is in alignment with the, what do you call, the Companies Act, other things is, so articles of association is another major document that is required. And also please ensure that there cannot be any special rights post listing. All those things, it's a forming part of your, So I'll come to this updated minutes and statutory records. Friends, this is the most important thing. Don't say I don't have records beyond 10 years. No, we can find out. We can find out. So many a time it might be handwritten minutes of the 80s and the 90s. Never mind. At least so long as you are able to locate it, because that also shows. See, friends, mind you, there is destruction of records rules for the regulator, not for us. And that's the reason. One of the thing, now you can argue under LODR was there is a preservation of documents, right? So don't, minutes and other things are permanent records, according to me. So we should be in a position to, update it, and the updated minute should be in place so that you get that kind of give that kind of a comfort. Okay. Then, of course, allotment to more than 50%. So now, if you see in the last, maybe, what do you call, even before 2015, a lot of companies would have issued or would have offered shares to more than 50 people. Why I'm talking about 50 is under the 56 Act, it was limited to, not more than 50% the private placement. Okay. So, many companies were, finding very difficult as to how do we convince the regulator as to whatever has happened, how do we do it, because there is no a clear-cut provision even in the Companies Act. And that's why, friends, SEBI had come out with a circular on December 31st, 2015, saying that, boss, if you fall under this, please follow this process. Now, one of the things which, if you look at that circular, what does it say? Okay, you have done a mistake. You have done a mistake. Fine, it will be, it will not be treated that way, provided you repay this entire subscription money with the 15% interest per annum to those shareholders if they are there, or if they are already transferred to the present shareholder. There is a process. I think it's a 2-pager circular, friends. You can always go and refer. So first, what I'm trying to say is, ek baar dekh lo whether the previously were there any allotments to more than 50 people which have been done. That's one of the things which I think you and I only can do, and we should do it. So immediately, if something has happened prior to that, look at this circular. What does it say? What is the process that you need to? Because all these things, if you keep it much before you file the DRHP with SEBI, I think SEBI is also will be in a position to quickly give its observations, friends. I think we should also give a lot of comfort to the regulators, right? So this is a broad role that, I would feel that you and I have to play at the beginning during this journey of 12 months to 18 months. I think if you start doing and keeping the things ready, I think many things will fall in place. And also don't forget, on before the DRHP is filed, you should, or much before, I would feel, I'll tell you why after some time, but much before the DRHP is filed, please ensure that your board and the committees constituted or have been constituted in line with the LODR2. Now you may be having under the Companies Act, but whether it is in line with the LODR, and also the terms of reference, whether it is you need to adopt what is there in the LODR much before the DRHP is filed. So ensure that it is. One of the small things which you and I can definitely do is, a lot of administrative work and lot of, resolutions have to be passed in terms of for execution purposes, which are not so material, but very important, very much important for us to, to carry on with this task of IPO. In that case, I would request, to form a small IPO committee consisting of 2-3 directors. Maybe if you want, you can have an independent director, but jarurat nahi hai. But yes, if you have, so that, practically, otherwise every time you need to call a board meeting for so many things and things. So, for example, friends, we write in the resolution, right? We write in the very, we copy paste many things and write very clearly, board, bracket may be write, including a committee which may be constituted or already constituted, taking this entire powers, another thing. What's the purpose of that? There is a purpose, right? So let's use that. So form a small committee and to do all this other than non-material, things that are required to do it, friends. Now, having said this, these are all in broadly. These are all the things. There are many more things as you go, as you dive down into the entire regime of the process of IPO. You'll find a lot of things to be done. Okay. Now, having said this, I think Rakesh told the promoter's background. Now let's go and see. Fine, you're doing simultaneously. You're doing, but there is this guy called a promoter, and there is a promoter group. Now, what do I have to do with those people? You have identified, okay, but whether there is something called the general eligibility criteria, whether they are falling in this or not, right? So, the merchant banker also does his own diligence for all these things through different websites, to find out, the genuinity of these statements which the company is making. So this is another thing which we need to be very clear of, so that's the general eligibility conditions, friends. Second comes, though, please let us not say this is not my area because this is more of the financials. No, friends, this is a regulation 6.1, which is very essential in this entire course of to decide which path to take. 6.1 is the main important thing that everybody, so please, we should know that whether we are falling under 6.1 or 6.2, maybe the way you draft the minutes, you can include very specifically that you fall under the root of 6.1. What is the importance of 6.1 and 6.2, friends? Because that's the main important thing that, let me see whether I have. So fine. Yes. We have broadly, these are the 3 players, right? One, the issuer. the intermediaries to this entire process. And the third one is, who are the investors? Who are the investors from whom we are taking money? So that's the third one, which is very important. Now I'll come to you. I told you, like, when this DIP guidance was introduced way back in 2000, one of the good things that they have done was, one was on the, the concept of book building. Secondly, on the categories of classification of the investors into different categories. Okay, there are three categories, friends: retail, non-institutional, qualified institutional, buyer. And what is the significance of each one of them? If you go and look at the general, if you look at this eligibility criteria, 6.1, if the issuer satisfies these conditions, then he is eligible to go under 6.1, in which case the allocation, or maybe the what is the maximum percentage that each guy can get, is mentioned in 6.1, which talks about in a 6.1 case, maximum, the qualified institutional buyers can invest is up to 50%. That's the maximum that they can invest. Retail investors can invest up to 35%, and the other one is 15%. But come 6.2, this is the most important thing from friends. Most of the issues, if you see, take Zomato or many other things, they will all fall under 6.2. One of them thing is, if you fall under 6.2, the allocation of the the issue is completely different. In such a case, at least 75% of the issue size should be subscribed by the qualified institutional buyer. The retail individual investor whose value doesn't exceed more than 2 lakhs is called the retail individual investors, which we all know, and remaining will fall under the non-institutional. But when I'm saying, at least 75%, there is a meaning to it, friends. Assuming there is another thing which again, we know that there is a concept of minimum subscription, under the Companies Act, under the ICBR, which is 90% of the issue size. And if the issue fails to garner even 90% of the thing, the issue could be underwritten. But mind, friends, if you fall under 6.2, where you have not satisfied those conditions, and if the issue fails, you cannot underwrite the issue. You will have to refund. The entire process. So please be mindful of this fact. And that's why 6.1 and 6.2 are very important, even from our angle, friends. Now, preparedness, another thing we just spoke about, Companies Act, because 24 not only talks about the companies that are listed, but also companies that intend to get listed. Okay, let the corporate governance requirement we just saw, let everything be in place much before and don't forget, the PIT regulations also talks about the proposed to be listed. I think the clock starts the time when you file the DRHP, when the offer document is filed. But many things happen even before that. Our question should be, friends, right from who handholds the issuer in all this process. The merchant banker handholds us in this entire process. He comes much before. He's the guy who really sees the entire environment, sees what kind of helping hand he can afford, and the guidance that he gives us from time to time to the issuer. All those things are very important. Understand, he comes much before, and he might be knowing a lot of things. So the question that comes is today, if why I'm talking about this is SDD is something which is always spoken about, right? Regulation 3, when you talk about this proposed to be listed also, at what point in time and who are the people to be covered. Also, please, friends, though it's not a big thing during the DRHP stage, but we need to have a SDD in place. So that's one word of caution that I just wanted to point out, like, please be, don't think it is only once you get listed. Even before that, it is highly important for us to have this in place, the STD in place. Okay. Power, minimum share. Okay. The minimum public shareholding limit, friends. This is also one of the very important thing that I just wanted to emphasize. Most of us know it is 25%, but where does it come from? Please go through 19(2)(b) SARA rules and see for yourself as to how does it define. It talks about 3 limits. three ways of arriving at. One is 25%. The other one is between 25 and 10%. So please, because all these things are also very important from a takeover code point of view also. So 19(2)(b) is one of the major thing which is required. Control, of course, take care. Shubham mentions not. So entry of Ps, I just touched upon initially that most of the companies today, if you see, have private equity players coming and helping the companies for maybe 2-3 years and other thing. Why do you think the startups also require this kind of people? Maybe a lot of push is required at the initial stage for them to come out and stand on their own foot. And that's the reason a lot of things are done. And this PEs are playing a greater role. So entry of PEs is making the companies to, at least to whatever extent possible, to work in a different culture which these guys expect them to do, because they play a vital role. Now, group companies, we saw what is a group company, and please go through the definition. Don't depend, let the merchant banker say anything, but please, friends, you have a table prepared, and you know your company better than anybody else, right? So please prepare. And there may be some companies which you might think, might fall under. Please bring them. Ek baar sab analyze kar lo, and then take a conscious call about which one to come and which need not have to be present. So group companies is also one of the very vital thing. And there is something called abridged prospectus. It is nothing but a condensed form of the prospectus, which is just into some 15-20 pages, which goes along with the application form, friends. Abridged prospect, there is a concept called abridged prospectus too. Okay, now in terms of financial statements, again, two things happen. I'll just touch upon the financial statement, friends, and then come to the other aspect. Okay. Now, what does financial statements? Earlier, it was for 5 audited years that we need to give audited results for the last 5 financial years, but now it is only 3 years that is required to be given. No doubt. Yes, fine, you can. But there is also something called, restated financials, friends. Now, what do you mean by a restated financials is one thing which we might be, restated is nothing but if during this last 3 years, if some, a material event has happened due to which your financials have been drawn based on that event, how will it look like if that event did not take place today? I mean, to put it very simply, it could have been an acquisition, it could have been a demerger, it could have been something else. How will it look like is what is. But don't ask me whether if I had done a buyback. No, that's not. But in terms of material events that have taken place, how do you treat this? That is the restated financials. Now, there is something called stop period also. So after the end of the year and before filing the DRHP, for example, you file it, say on September 25th. Because the financial statements cannot be more than 6 months old. Now, how do you deal with this interim period? And that's where you need to draw unaudited financial, because being an unlisted entity, you are not, you need not have to have the results, quarterly results approved by your board, but draw up that for that period is very important. At least for September 25th, you need to have up to August 31st, and then present it in the, because we also know, right, any event that has happened material events that have happened post the close of the financial year has to be reported in the board's reporting, right? That's also is one of the factors. So that is called the stub period thing. Financial statements is restated financial statements. Now, where I'm emphasizing this is in the DRHP, you will comprehensively, it covers everything. So your board approves the DRHP, but there are certain elements. One, we saw the material, the litigations, the materiality threshold that needs to be set. And here also, friends, whenever it comes, financial statements, please pass separate resolutions, because this is a restated financial statements, and the auditors and the board, the way the financial audited statements are signed, the same way this has to be signed. Hence, make a separate resolution for this, because many a time I have seen many people have not done this. Hence, my request is, please, if you could do that, it's a good step. So do pass a separate resolution for each of these items, friends. Then third thing comes is, Indian companies, can go and market this entire public issue throughout the world. In each jurisdiction has its own limitations. It has got its own laws and the regulations to be followed. But one such thing is, if you go to US, there are two ways or two things that you need to keep in mind, and this is very crucial, friends. One is, there is something called Reg S issue and 144A issue. Now, what does 144A talks about of the US Securities Act? Okay, not the Companies Act of the present one, 144 plates. So it is, what does it basically talk about? It says that any guy who is coming and marketing in US, has to follow certain guidelines very clearly. One such guideline being that when we spoke that under the current Indian regulatory framework, the audited financials cannot be more than 6 months. Under the US regulatory framework, the audited accounts cannot be more than 135 days. Okay, so your planning of filing the DRHP from the year end should be planned in such a way that you file it before, if you happen to file it. So, of course, there are foreign lawyers who will advise us on all these things, but be mindful of that factor too, friends. So, financial statement, this is one thing which I just wanted to. I think we all know that when the board approval, the shareholder 62(1)(c) and all those things, apply for an in-principle approval and then get the final. So, listing again on the main board, SMEs and innovators, the growth platform, it has never taken off, though it's a beautiful concept that ICDR talks about, but it has never, it never took off. And SMEs, of course, we all know it's also, being looked at. Okay, now, book building and so let me just what's typically happening today is the book building exercise where what do you call under the financial parlance, it's nothing but a Dutch auction method of arriving at a price when you have a price band. So DIP guidelines introduced this concept of book building wherein the issuers were allowed to fix a price between, which can't exceed more than 20%, which can't exceed more than 20%, then how do you arrive at it? That's why you are seeing, right, that lower end of the band and the higher end of the band, if you see all the ads and other things, now this is within the price band, So when you do the price, the book building exercise based on the Dutch auction method, you will know which price to do it. But Indian, typical Indian scenario, has, if you ask me really, book building, whether it has taken its own shape in India, really it has not, because it's always subscribed by the, the highest band. Because under the Dutch auction, the price at which the maximum number of shares are tendered would be the price at which this would be construed as the final price. Okay, so you do that book building exercise. Now, what companies were doing, friends, is they used to keep a price, when you have a chance of giving a price band of 20%, people were doing it 800 rupees to 801. Is this a price band? Is this a price band? Not at all, right? Hence, there has been an amendment to this saying that at least the price band should have a 5% difference between the lower and the higher end of the band. So the 5%. Now, again, friends, I'll go to the minutes. When you finally, pass a resolution for all these things, when you do this, the price band, please pass a separate resolution for this. I'm emphasizing all these things, friends, because I think it is we who can drive this entire show is what I would always believe, and I will always believe, so please have a separate resolution for, okay. Now, just for the benefit of everybody, friends, I think some of us might be knowing about these things, but really let us, many issues you see, it's being priced at some price, and finally post listing it comes down, and then we feel why this has happened. So the regulators, now I can't go back to the CCA regime, right? It's almost now 31 years when SEBI has been established now, right? So I can't go back to the CCA regime and ask him to fix a price for me. So, but at the same time, being the promoter of an enterprise, I would definitely expect a good price for my share, and that's where that expectation, the greedy expectation, sometimes, not always, but sometimes the greedy expectation versus the reality has to be bridged by this merchant banker. So how does it? Even he does this kind of an exercise, basically. So each merchant banker, most of them will have so-called the research guys, a research team, research analysts within them, and they do a lot of research because they know the sectors in which these companies operating, and they would have been doing this because this is something which you and I will not be really been exposed to this one. So he does his own calculation about what is the maximum valuation that this guy can get, and then slowly when you file, after filing the DRHP, when you go and really do the road shows, when you do the marketing, each one of these so-called the institutional investors or the QIBs, based on their own analysis, they will be able to tell you that this is the quantum that, for example, if I have to raise say 3,000 crores today, I'll go to one mutual fund and say, boss, how many? He will be ready to say take 100 crores. Somebody will say 50. Somebody will say I can take 500 crores. So it all depends on that, and finally, based on that, they will also arrive at a particular resolution. But don't forget, friends, even the financial models that you deploy for arriving at valuation methods that you apply is also one of the very basic thing that will also be taken into effect before you do it. And finally, you go around and find out what is the ballpark figure, what is the range that different so-called the QIBs are talking about, and because ultimately you need them in the show, right? So and that's the reason you finally arrive at and convince the issuer that this is the realistic price at which you will be able to come do it. Let me see, because there is some. Let me just tell you one last. Sorry. Okay, this is what does the latest one there, and this is very important for all of us, friends. There is something called key performance indicators. Like how when you arrive at a price, what are the different things that goes into the issuer's mind? If you today look at the KPIs, maybe this has come in, I think, November 22 amendment. So if you look at the documents today, you will have this in picture. What are all the different elements, and what is the sensitivity analysis that a company does when something happens to it, and what is the impact that it will have on this? So that is one thing which is very, very important KPI indicators, and these details have to be minute. You will have to take it in the minutes, friends, because there is a table which talks about KPI parameters, and which is also very important. Now the main important thing is on the confirmation by the audit committee. Now that's why I said the constitution of the committee should be much before you file the DRHP. So it's a confirmation on the KPIs that the management has drawn out. So there is an additional terms of reference to the audit committee much before you get into and file it with the regulator. And most important thing is, don't forget, though it is not that has not come out in LODR, at least to my memory, post listing, there has to be a disclosure, at least for a year or till the proceeds are being utilized. One, we all know the deviations in the use of the proceeds is one thing, but other factor is also, they will analyze if there is any change, if there is any change that has to be reported post this. So audit committee has two things. One, we have what you call as a monitoring agency, which is required to be appointed for any issue of more than 100 crores. When they submit a report to the audit committee, any deviation has to be reported both in the financial results and as a separate thing. Along with this, This is also on the anvil, friends. Now, I don't know whether I'll get time to cover one thing, but role of independent directors. I just wanted to emphasize on this aspect also, friends. Maybe I'll just role of independent directors. What does what do the independent directors do in an IPO? The role of independent directors, it's not only restricted to the Companies Act, friends. When you get into the listed space, even in preferential offer and takeovers is the first one which had this, recommending the, whether the acquisition is beneficial to the shareholders. That was, but then came the preferential offer and then the IPO. Now, what do they have to see? Now, the independent directors have to, now there is a small thing here, all the independent directors have to give. It's not that, independent director, and that's why, with his absence, no, it's all the independent directors have to give the justification on the basis of offer price. So what is this weighted whack of primary and secondary acquisitions? Or basically, lot of things would have happened, lot of transfers, lot of issues companies do make, before they launch the DRHP with SEBI. And has there been a difference, what do you call the price differentiation? Because you would have allotted shares at 57 rupees, but today, just 2 months back, you would have allotted at 57. Today, when you are coming to the market, you might be charging some 300 rupees. Now, what is the justification? Is there any justification for that? And that's where, all the inputs which are required to be given to the independent directors. So one of the thing, so in case of a company pre-IPO, when you have this independent directors meeting, apart from what is required under Schedule 4 to the Companies Act, this is also one of the things that is required to be done by the independent directors, friends. So don't forget, audit committee has a role to play much before you file the DRHP. Independent directors also have to play much role in this, because these are all some of the amendments and the changes that have come, and we are directly, I would believe that we are directly involved in all these things. Okay, this is allotment of shares, which I had already said. Very peculiarly, I saw one particular word, or such higher return as promised to investors. So that means there have been companies in Indian companies which have been promising returns to the gullible investors, saying that invest karo, aapko itna mil jayega, those kind of stuff. So all those things, are put to rest now. So that is one of the other thing is, please define your objects of the issue very clearly, friends. Objects of the issue is very, very important. A thing that is required to be drawn up. The utilization of proceeds is also very important to be drawn up very clearly. One of the things that the regulator sees is whether the objects could be understood by a layman, by a normal investor, or is it some very technically worded, or is there anything inside, anything within, that is not understandable or that is not comprehensible in this entire objects. So please define the objects very clearly. And there is something called general corporate purposes, and the issue size, only 25% of the issue size can be allocated for this general corporate purposes, and not more than that. If you look at ICDR, it also gives a small leeway to go up to 35% in a particular case. Please, so objects of the issue is very important, because once your objects are not clear, or secondly, there are certain things which the regulator feels, that this is not a company that should be allowed to go ahead with the public issue. Please be mindful of the fact that there is something called rejection of offer documents, because we know, the reputation of the company once the document is rejected, what is the kind of reaction that we will have, and the reputational, damage that can happen. So please ensure that all these things are in place. So if you go look at this general circular of SEBI, you will get to know what are all the different things, friends, two friends. Okay, so there are many instances, if you go and look at some of the cases which happened in 2000, the promoters and the companies were debarred from accessing the capital market, and because of these things. And so objects of the issue should be very clearly spelled out in your in your DRHP very clearly. So road shows, we just saw the road shows, another thing. Now going forward, having said this, what is the process that you need to follow? I'll file this entire DRHP with SEBI and wait for and also post it on our website, the lead manager's website, exchange's website, etc. And all these things you do it, and ultimately wait for the comments of the public too. So once that comes in place, then also the SEBI also gives its observations should give within 30 days. But the more and more the information is being sought, you need to provide satisfactory replies, so that all those things will form part of the issue document. And that's the reason you wait for some time, respond to the queries of the regulators. And when I say the regulators, even the stock exchanges here, I mean to say the stock exchange. Don't forget to look into the basic requirements of the stock exchanges, friends, because sometimes you'll get by surprise, you'll get some surprises. So please go through the checklist of the listing documents and the listing things that are required to be put in place right at the beginning. Okay. So having said this, once SEBI gives its permission, then, with all those observations, you file what you call as the updated, now it is called the updated DRHP. And once that is also there, then you file the RHP, and, the price band you fix. And what is the, when do you announce the price band? Because the DRHP doesn't contain the price band. And this is the time where you have to fix, either you put it in the RHP, or maybe, you can give an advertisement 2 working days before the issue opens, and that's how. And then simultaneously, RHP is also filed with the ROC, friends. So a small thing on the, on the filing with ROC now. Prior to 2018, there was this concept of getting your prospectus registered with ROC. But now it is very clear, effective September, I think, 2018, it is enough that we file the RHP and need not wait for. But typically it all happens in a day. But the law is very clear, from registration, it is only a filing now. Please be mindful. So nothing to worry on that front. It's only a filing with ROC that is required. So once you file it, open the issue, keep it open for a minimum of 3 days to maximum 10 days. Why that is given? Because if you want to change, if there is a meek response from the subscribers to the issue, you can always extend. So friends, all these things have happened in the past too, and that's the reason this provisions have been given. So you can extend it to another, but maximum of 10 days is what you can go up to. And so you can revise the price band. That's what I just want to tell you. You can revise the price band to that extent, So I'm telling you all this, friends. Here is the role that you and I have to play, very, very vital. And I would request all of us, when we do this kind of a project, we need to help our own colleagues in helping out, Okay. So promoters contribution, ASF, ASF 20%, all those things. But only one thing is lock-in. Lock-in is very important, because any percentage more than 20% held by the promoter and promoter group will be locked in for 18 months. Earlier it was 3 years, now it is 18 months. And for any other guy who was holding pre-IPO shareholders, all those shares have to be locked in for a period of 6 months. So lock-in provision is also, because what typically happens in very practically is to, you need to identify the numbers and other things. Practically, this is a difficulty. Free friends, when you do the capital build up simultaneously, or distinctive numbers bhi dalte jao. I think this is one of the major things that you and I will, we should not waste time. I mean, that's the only thing which I'm trying to emphasize on this, on this. So many a time it also comes post listing, whether promoters can transfer. Yes, you can. The flexibility has been given. You need to just look into the, intrastate transfer among the promoters under the takeover code, and go ahead with that. There are many other descriptions. Let's not, I got something else to do it. Now, anchor investor, who is this anchor investor? He is a guy, he is nothing but a QIB, but comes one day prior to the opening of the issue and subscribes to this. So you can look into any company, friends, just before a day it opens. For example, if it opens tomorrow, today, at the end of the day, maybe late evening, you can see who are the anchor investors who had subscribed and at what price they have subscribed. So it will give you a broad idea about who has been the anchor investor. There has been some conditions for each one of the anchor investors as to what they do, and earlier it was there for a few years, but there is nothing, there is no credit rating. That is one thing. And a lot of promoter groups transaction that happens till that time, even before the closure of the issue, 1 day prior, 10 days prior to the issue opening, you need to continuously, you need to continuously disclose it to the in the offer document itself. So this is also, please be mindful of this restriction on further capital, because some tendency is that you open the issue. I mean, you try to do an IPO and also try to make an issue within the next 3 to 4 months, but categorically there is a restriction that you should not do this unless you have made adequate disclosures in the offer document. That is also a very important aspect that we have to remember, friends. And this convertibles to be converted before filing of the RHP. So whatever convertibles you have before before getting into filing the RHP, ensure that all those convertible instruments are getting converted. Please one more thing, friends, as an instrument that is eligible to be issued under the form in an IPO is not only equity shares, you can also issue convertibles in the IPO. I'm trying to say in the IPO you can very specifically and have issue, and even warrants could be issued along with the along with the equity shares. Now, as and all, I think we all know research report. I just talked about research report, which the research analysts prepare, based on his own analysis. And there are a lot of, restrictions for him to, to interact with the merchant bankers and all those stuff, which will be taken care of by the merchant bankers based on their code of conduct, and also the confidentiality of the UPSI, and of course. Now, one of the things, please, again, friends, none of the DRHP you will find projections. Don't think that the pricing is based on the future projections. No, right from 2000, once the DIP guidelines came, this concept of giving projections has been completely stopped. There is nothing. So it is all based on our own research that the QIBs and the institutional investors do, subscribe to the issue. Now, what is this pre-IPO placement? All these things are jargons, friends. The pre-IPO placement is all, coined by the, during the course of the IPOs thing, So what is this pre-IPO placement? Is nothing but a private placement, or what you call as a preferential offer. That's all. So whatever needs to be done, you can do it. The only difference is pre-IPO placement, you can have a secondary transaction. Somebody can transfer his or its shares, that's the only difference. Otherwise, don't get carried away. Everything has to fall in place within the Companies Act. And no incentives, all those monetary agencies I talked about. Again, being one of the major thing, friends, as far as directors are concerned in an IPO, please take up all their backups. Right from their educational qualification down to the experience and whatever, if they are on any associated with any associations, whatever, please, it's very, it's easy to say and put it in a document, but it is very essential. The merchant banker will be after you to get all these things. Please don't get irritated. Find out a way. Many people may not have their basic education. The only thing is, if you do not have a backup document, these things will not be put in the offer document. That's the thing. Please. And also, some of all these things will be taken care of by the merchant banker, the words, the leading player, etc., for no forward-looking statement. Forward-looking statement, but also we believe, and all those kind of English quotes will be comes outstanding litigations. We saw summary of RPT prepare karke rakho, friends. Now, all this, we may be attending so many sessions and other thing, but RPT, even for unlisted entities, before you go into the IPO market, the summary of RPT in the last 3 years is also very, very important. And size of pre-IPO, why I'm talking about this is, whatever you do, the pre-IPO placement happens between DRHP and RHP, friends. So, because if it happens before DRHP, or you would have already included in it. So this happens prior to the opening of the issue. So, what if that is there, then the size of the IPO would get reduced to that extent. So the restrictive covenants is thought that it cannot have anything. Disclosures, again, we already covered under the materiality threshold of the board approved policies. So even while mentioning the risk factors, there is a way to mention which all the criminal proceedings will come at the top, and depending on the intensity of the other things will, the risk factors will be numbered and serially done. Okay, so then there is something called, this is also very important. Typically happens in many of the concerns where even after filing DRHP, there is a change in the mindset of the promoter or the management, saying that why can't they change the issue? Says, please be mindful of that, friends. There is a percentage beyond which you cannot change. So please be mindful of that fact, and if it is falling within that, it's fine. Otherwise, but again, you need to go to the board, mention very clearly about what is the change that has happened. So all those things are very important. Of course, all these things will be taken care of by our merchant banker friends, so not to worry. But at the same time, we should give that comfort. For example, the IPRs. IPRs, if you have, please again do an audit much before you do it, because this is especially for those companies where IPR is a real property for them. So be careful about mindful of dividend policy. Of course, if you're a listed, we already have a dividend policy. We'll be having, but even for an unlisted, it is required to have a material policy. Management discussion, though we may not, it's all totally business driven, but nazar laga sakta hai ki, what typically goes into this. Now come this exit opportunity. What does this mean, friends? Exit opportunity we would not have heard about all these things. Now today, if you look at section 230, where you file what do you call a merger petition before the NCLT, there is a provision in section 230 which talks about giving an exit option to the dissenting shareholders. Okay, now that's a new thing which has come in section 230. But here is a case where I have mentioned, that's why objects of the issue is very important, that if there is a change, if there is a variation in the objects of the issue post the public issue, then an exit opportunity has to be given to the shareholders. Okay. Now there is a separate, the chapter for this in the ICDR as to what are the different methods that you follow. So, and even in this case, there is a limit. Only 5% whoever comes first will be given this opportunity, and very, very, in fact, in my whatever knowledge I have is that I could find there is only one company that has gone into this process. So, and what is the process? It's they lay down in ICDR, but before that, please also look into section 27 of the Companies Act. Rejection, we saw the rejection of offer documents, so. Now poses, in the sense, what are the promoter's obligations in an IPO post? If something happens, what are the liabilities of directors, including the independent directors, whether they can take recourse under 149(12). All those things are very important. Any special rights to the private equity investors that have been given should fall after the issue, and many material development that has taken place needs to be informed to the regulators from time to time. So, once you open the issue, there was a time when it was open for 42 days, 21 days, and 12 was prevalent for quite some time. Then we had T+6, and come today it is T+3, friends. And all the companies effective from 1st of January 2024 has to complete this process of IPO listing within 3 days. So T+6, it is being tested T+3 in 2 stages. Some of the companies are doing even now, and others, for everybody, it is going to be a compulsory thing that within 3 days, T+3, we need to get the shares listed. Now, we saw DRHP file, UDRHP, and etc., etc. There is a new concept that SEBI has introduced sometime in November 2022, and which is called as the confidential filing. Let me just give you a small hint about what is this qualified filing, which okay, this is the new mechanism which talks about. There are 3 stages here, friends. One is, here what typically happens is it's called the pre-file draft document. So you file it with SEBI, and it is not publicly open. It is not publicly open. So only the issuer and the and SEBI will come to know about this. Not even with the exchanges. So you file it with SEBI. That's why it is called a confidential filing. The only thing is, in terms of, you have an advertisement released within 2 days, and then in between this, SEBI, before SEBI gives its observations, you can start interacting with QIBs, because today typically what happens is the road shows and everything, road shows and everything happens. A lot of time is getting wasted because the valuation also based on because primary market is also the secondary market is a barometer for determining IPO price too, right? And hence, the gap between those 2 things should be minimized, and hence you file it and find out what is the expectation of the QIBs. So once you get the observations from SEBI, then you file what you call as incorporate that, and then you file it with SEBI again. It's called the DRHP1, and which should be now available in the public domain, and because it should be kept open for 21 days for anybody to comment on that front. And then once you incorporate both the things, you file the final one. So this is a mechanism. And again, to my knowledge, I don't know. To my knowledge, if you look at the Tata Technologies, which is going to open now, this is following this method of Regulation 59A. So that is one company which I think that it was the first company to file, in fact. But the issue is going to open maybe in a few days' time. Okay, so this is another method, friends, that is available to the companies to do it. The only requirement is we saw the RHP and prospectus filing, but here the last one, the draft red herring prospectus, after incorporating the comments of SEBI and the public, have to be filed with ROC. Of course, don't forget the prospectus also needs to be filed with ROC. The only thing is the issue should be, should have to open within 18 months from the receipt of the SEBI observation. That needs to be kept in mind before doing this. Another thing, Rakesh, I'm just telling which are the important things for all of us to broadly we should be knowing, friends. And that's the reason, I'm taking some time, So there is something called minimum public shareholding limit, which we saw, right? Rule 19(2)(b). So when you fall under 25 to 10%, when the public is holding only between 10 and 25%, how does, within a period of 3 years, the promoters have to, make the public shareholding to 25%? How do you bring it? There are different methods that SEBI has laid down. You can go through those circulars very clearly. But please, friends, only one thing. This is rights issue and bonus issue to public shareholders. The promoters will not participate. Now, how will you draft that resolution? How do you do it? All those things are very important. Don't say that, rights issue as per ICDR and its circulars, etc., etc. How do you do it? This is a concept not envisaged under the Companies Act, but it's a part of the ICDR, which you have to do it. Right. So there are many things. For example, there is something called offer for sale through stock exchange mechanisms, and there is something called sale of shares by the promoter or based on certain conditions. If you look at the circular, you will get to know what are all the different things that have to be. ESOP schemes, that's okay. Then very new thing again as a part of that notification, the promoters can transfer their shares to a ETF. Okay, maybe we need to see how these things happen, but yes, please be mindful of this fact that minimum public, how are the ways and what are the ways in which the minimum public shareholding limit can be increased, and any other method as may be approved by the board. By the board in the sense the SEBI board, not the board of directors. Okay. Now there could be a lot of structuring innovations that can happen, friends. And for example, there's a best thing that you should look into is go and look at the Wipro scheme of November 2012. It talks about how they have increased the minimum public shareholding to 25%. That's one of the beautiful demerger scheme that I have ever seen. So, so that is one way in which the promoters can they can increase, and there is an adjustment to the KPIs. We saw there is an adjustment to the pricing, because all these things are very important, friends, because when you place before the independent directors, the details of this have to be in front of them, and that's the reason I'm just emphasizing on this fact. So just on the preferential issue, I just very important learnings that we have, friends. Preferential issue and QIPs are two easy methods of raising funds, by the promoters for the companies, because it all can happen, say in a matter of 30 to 45 days, everything can get work. But preferential allotment, there have been some radical changes ever since the PNB housing finance episode happened. So let's be one of the first thing, friends, you should remember is that in case of a preferential offer, now don't go under the exact wording of 62(1)(c), but in case of any private, I will put it as a private placement, that your preferential offer, your document, your articles of association should authorize. So when you do your diligence, please, when you do a preferential allotment, ek baar pura, what does the preferential issue guideline say? Regulation 158 to 170, what does it say? And what does 62(1) read with 42 say? Please, along with the rules, ek baar checklist bana do, you will get plenty of answers. One such thing is, that your articles should authorize the issue of on a preferential. There are some conditions that are required to be done. But what are the learnings from the PNB housing episode? One, importance of articles was prescribed, and many a time articles of association contains the pricing. Whenever you need to do a further offer, it has to be based on the book value or the methodology that is adopted. So even though the ICTR guidelines give you a provision, pricing formula to determine what's the minimum price that the issuers can charge, can price their issue, but if the articles of association mentions a higher price, that should be the case. That's the first learning that this has taught. So you just go, and if at all there is a provision in the articles, so though you should be mindful of that fact. So whether it is there, so whenever, even before IPO, if you have such kind of provisions, whenever you change the articles, it's easy to change the articles prior to the IPO. So better to remove all those things is what I wanted to convey. And the entire preferential issue under the regulation 158 to 70, the practicing company secretaries have to certify that it is in compliance with all the regulations of 158 to 170. So there is an ample opportunity for the PCS friends. So this is, that's where the CS on the corporate side should help them. So that is one. Secondly, on the QIPs, this is as opposed to a preferential, though it's a part of the preferential offer, this is offered only to the QIBs. Okay. And so this is offered only to the QIBs. There's a very interesting instrument, if you see, friends, it's an NCDs along with warrants. One is a debt instrument, but there is another convertible instrument that goes with this. In case of a preferential issue, if you issue warrants, this has to be converted within 18 months. But in case of a QIP, it could be converted within a period of 60 months. So again, your wording and other things. One more thing I forgot. Even in an IPO, there are some reservations. There are differential pricing for employees or to some of the the shareholders of the listed entity in the group and etc. etc. So please be mindful of wording your resolutions very carefully about the pricing. Again, I will emphasize, don't just depend only on the DRHP resolution. That's a motherly resolution which you pass. But inside, you need to have all these things done as well, friends. So, one of the, I'll just skip for a second and I'll show some other thing, friends. Interesting things happened, during, what do you call, 2021, 22, very good things have happened, friends. Okay, this is all tech startups, whatever. Zomato, there are three cases which I just wanted to, tell you here. And all the three are, especially two. One is very, very important thing, friends. Zomato, it came at the correct. Oh, sorry. Oh, sorry. Avi? Rakesh, it is visible now?
Yes, sir. Visible.
Okay. Okay, so it's basically on the startups, but Zomato, I call it the great escape because it came at a very correct time and the market was, booming. And June 2021, I think they came out at the public issue. And though the price band was 72 to 76, we all know to what extent it went up. Okay. Rakesh, for a couple of minutes, I'll switch on my. There is some connectivity issue, so a couple of minutes I'll switch off my video, please.
Okay, sir.
Okay. So Zomato, I'll call it the great escape because then the the listing price went up to 136, 139, whatever. To that extent, it went up, and finally, today what the price of it, and I think the only thing they came at the correct time, so. Price band, as I said, listing price, whatever it is. So risk factor, this was the risk factor. The first risk factor is this. You have a history of net losses and etc. And, one doesn't know when they will be. I heard that they are in the process of showing some good results, Zomato. But then we all know, Paytm, I call it the Titanic. We know how it shaped and how it tanked. And, due to that, the entire the market also took a different shape. So I call it the Titanic, the Paytm thing. But in between, there was one thing called the Smart Balancer. I call it the Smart Balancer. The Star Health Insurance Company, friends. What did they do? If you look at this, the price band was this. They opened the announcement date, offer was closed, but they issued an addendum on 6th of December and the offer for sale reduced. See, 6,600 was the 400 was the issue size initially. Then once they found that the pricing was slightly on the higher side, instead of reducing the price band, they reduced the issue size, not the primary issue, but the offer for sale, whatever the issue. But now, this is where, friends, our entire, how do we do it? How do we how do we pass the different resolutions? How do you put it before the board? All those things are very crucial, and that's the reason I just wanted to, understand, whether this is feasible or not, though we have the lawyers on our side and the merchant bankers also to, find the regulatory expectations on this. But ultimately, it is one thing which you and I should be aware of, that in such a case, there is a possibility of reducing this as well. So that's the reason I call it three different things. So that's all okay now. Let me just, again, I'll stop this. And one of the major thing, friends, is, as I told at the beginning, there are plenty of opportunities. Plenty of opportunities for us, friends, in terms of, Anusha, it's okay, Rakesh?
Sir.
Yeah. So AIF, alternative investment funds, this is one of the wonderful areas, where I think we as company secretaries can play a very, very, very great role in this. AF is nothing. It is similar to a mutual fund, friends, where, instead of mutual funds now typically focus on the retail investors, these people focus on, slightly, what do you call as high net worth individuals or the corporates, which is, ready to put in the funds. So this is something, but it has its own structure. Like there are three categories of category 1, 2, and 3. I think some of us might already been doing, but there are plenty of opportunities. Let us not let us use this opportunity to and again, typically alternative funds, it has got different kinds of funds within that. Each category, it has its own funds. Category 1, 2, and 3. Category 3 is more of a hedging activity where it can borrow and play it. So hedging is one of the concepts which India had never seen, but through this route, hedging is also is in the work. And so what typically happens, category 1 is more of a social sector. Category 2 is what you will find a lot of AFs. There are around 1,300 AFs in India, but most of the things you will find in the category 2, because that's where you can invest in any kind of thing. Who are the eligible investors? Mode of issuance, everything is very clearly laid down in the AF regulations. And now come to the you can go through the AF regulations, friends, but come to the angel funds. Many of us we feel we talk about angel funds, angel investors, and other thing. But it's all very clearly defined as to who could be an angel investor. They are special type of investors, and what do they satisfy, and where all can they invest. There is plenty of opportunity, and restrictions, special situation, friends. I'm not getting into other role. The anchor investors, initially these people were not part of the anchor role. Now they can play not only as a QIB, friends, even in this promoters. In some cases, what happens is the promoters contribution of 20%. When they fail to get that, only AF can pitch in and come and bridge that gap between the promoters' contribution and this. Only that has been given to them. Now, role of CS. Now there are different, you have a trust, you have an investment manager, you have a trustee, all those things are there. Right from the beginning, when you make an application to SEBI, right from forming the trust down to getting your, the registration done or approvals from SEBI, and also then going forward, what do you call, convening or complying with all the provisions of the AF regulations. It's a very interesting piece, friends. So, whoever is interested should go through these regulations. It's akin to a mutual fund regulations, but never mind. We have plenty of opportunities, so don't miss this opportunity. And also, I would like to take a couple of Chalagana Rakesh, I want to touch on InVITs and reads for 2-3 minutes. That's all.
Sure, sir. Sure.
So what is this InVITs all about? It's today what is happening is, we know how the infrastructure development is necessary for any economy, right? And, whenever you want to invest in infrastructure projects, it's a very lengthy, the gestation period is something very long, and you need to wait. Any investor has to wait for his return for quite some time. See, if you look at the changes that have come in 2013 Act, the debentures, the period was from 10 to 20, 30 years, and even for redeemable preference shares, we have from 10 to 20, right? So all those things were intended. That's why even the redemption of preference shares, if you see, there is a small difference between when you redeem for a normal company vis-a-vis infrastructure company. And so, but never mind, it really did not, I would feel, really did not kick off. So that's why in 2014, or maybe really parallelly, SEBI came out and introduced a regulation where, it will be benefiting all the infrastructure companies in finding a suitable investing opportunity. So this is basically, where it enables infrastructure companies are, that enables developers to, in the sense, developers borrow money and invest in these different projects, but how do they monetize and how do they sell it back? So there is a structure which is being created, this is the structure for an InvIT, friends. Looks very complicated, but a simple thing, I float an InvIT where I'm as a sponsor, I invest some money, and then there are other investors who come and also invest, and basically then it takes off. So you have an investment manager. Here the investment manager is a very crucial guy, and the role that an investment manager plays, friends. There are two roles that we can definitely play in this. One, this entire process of setting up an AF and down to handling to the investment manager, or as an investment manager, the compliance role that we can play is something tremendous, friends. So it looks like a complicated structure, but very simple. I'm a holding company. I got different because all the infrastructure projects are put in a particular special purpose vehicle, and and based on that you invest, and the project manager is there to take care of that. So how does InvIT raise funds? It's more either through the public issue or through a private placement. And understand, friends, unlike AF, the InvITs have to be listed, whether it is privately placed or whether it is through the funding, whether it is through the IPO route. So the process again for IPO is, it did not have a lengthy process, but effective July 2023, the process has been made similar to that of an, I would not say in all category, but I think 80-85% is almost similar to the IPO of an equity shares. Okay, so private placement is another angle. See, all these things, what typically happens is, and where all investment can be made by the InvIT, in different projects, and what is the return that InvIT gets? There is something called the income. How does it get the contribution from or the distributable income of all the SPVs that happens? Look like all this looks like a very jargon, but if you go and sit and analyze, it's a very simple process to understand, friend. But there is a compliance, there is a periodic filing. So role of CS, I'm just putting it. Let's put this in front and see what all the, as I said, for AF setting up a trust. Here you can play two roles: set up the or again go to the investment manager, because here the entire responsibility lies on the investment manager, friends. Okay, so and all the agreements that are getting drafted and other thing, you can be a part of it. You can be if you have some interest or passion for drafting agreements, I think this will be a wonderful area where you and I can look, and drafting offer document, diligence, and everything, typical of what you and I can do it with ease. I'm saying it's initial stage pe thoda, we might feel some discomfort, but I think later on, I think we can teach. And so similarly, when reads, I'm not showing I think because I need to give some time for if at all there is any question. So since this is concentrated on the infrastructure projects, REITs is nothing but same structure, but it will be concentrated on the real estate developers, real estate properties, where you get the same kind of process. Where there, real estate, the only advantage is there you can see the income flowing, right? Whether you give it on rent or you sell it, the income flows from regularly flows to you, and that's the greatest advantage of thing. And yes, today, if you ask me, in which there are some 24 or 26, 27 listed space, and of course, REITs, it's only some 4 or 5, and because it is also taking its own time to to put a proper, and that's the reason this. But friends, never mind, that's on the business side, but I think the role of a CS, you can definitely do it. That's what I just wanted. 1 second, I don't think I have missed anything, Rakesh. 1 second, if at all, I think I've spoken of everything, but there is. So a lot of case laws, friends. You might be wondering why, what do you call in an IPO, are there not case laws? You can go and there are a lot of, all these things, huge difference. I had just touched, there is Sterling and Wilson is a typical example of how we should be careful with the size of the issue. All these things, when you look into each one of them is, for example, this, I think Takshil Solutions, they never had a land enough, they showed as if they had had a land in a particular area of Andhra Pradesh, but it never existed. Sorry, it existed, but it belonged to the forest department, So all those things was, is one of the things. So there are plenty of, again, each and everything will give you a lot of, please, it all depends on the passion that we have. And, so the role of rejection of offer documents, if you have, again, you go back and, the offer document are subject to rejection. And that's how it should be. And, okay, Rakesh, I think that's how I thought, broadly to share whatever I knew of the fundraising process. Only one thing, please, friends, even IPO of NCDs, typically NCD is a company that is not equity listed, but can list its NCDs on its, there you don't have this chucker of going to CB and the DRHP and other thing. They're only draft, prospectus, you file it with the exchange, wait for 7 days, get its principal approval, and then go ahead and launch the issue. And there it is like a first come, first serve basis. And almost the process, if an IPO of an equity takes 6 months, that's an easy process of 3 months, but more or less the disclosures have to be same. In fact, all the more in case of IPO of NCDs, because it's a debt instrument where you'll have to make the commitment of paying interest in a timely commitment of making the interest payment. So, and the credit rating is important. Of course, privately placed and IPO. If it is a privately placed, please go through the electronic bidding platform on the exchange for private placement. How do you arrive at it? How does it, do it? That's an interesting story about electronic bidding process. So privately placed NCDs and what are all the different LODR. Of course, once you list, you have to be with LODR. So, and that's what Rakesh and, I felt of sharing this evening with our fellow members. Thanks, friends. I don't know, out of whatever the number which the technical team can give, how many of them were really attentive, but never mind. Thanks for joining even immediately after Diwali holidays, and thanks for attending. So over to you, Rakesh.
Thank you, sir. Thanks for, giving us such a enriching session on the fundraising by companies. In fact, you covered the various practical aspects which we were not aware earlier. In fact, I went to my training days when I was working for a company and the company was planning for a further public offering, and the merchant banker was asking every day for new documents and records, and we are going to, find out from where we have to take it. So I just went to those days. And sir, we have few queries. If you allow, I can take it one by one.
Yeah. So easy hai wo le lo, Rakesh.
Sir, all queries are easy for you. Because your session is so enlightening, we not have much queries, but still there are few.
Take it, please.
Yeah.
Please.
Sir, as you talk about the pre-IPO placement,
Anji,
there is one query. Can the pre-placement price be lower than the IPO price? If yes, how much it can vary?
No, the first answer is it can be different. It will be different. It will be different because there is a difference between pre-IPO placement timing and the IPO side. But there is nothing, real legal rule to say that this should be the difference. But yes, you should be careful. Why did you have today adjustment in price when I told you about the price band that is getting fixed and the independent directors have to get the recommendation? This all will count. So it cannot be, as I said, the difference of 57 rupees versus 300 within a 3 months of time is not tenable at all. So we need to be a very reasonable thing, which that's why the independent directors also have to recommend this is what. So there is a possibility you can, definitely it will have, in my view, there will be a difference, but it should not be a huge. 57 can be 77 or 80 to some extent, but again, you need to justify,
Yeah, it has to be reasonable, sir. Yeah, sir, there is one question that slightly different, that how to raise a fund for a Section 8 company.
Okay, sorry, I forgot to tell you. I'll take 1 minute. 1 minute. Say, okay. A Section 8 company. Now, I think friends, go and look at ICDR 292A. regulation, start reading that. There is this concept called social stock exchange. Okay. Now, what are those two things? One, Section 8 company, and secondly, it is what do you call as the NGOs. Now, this new concept, how it has triggered was in 2022 budget. I think the finance minister announced saying that NGOs also have to be brought to the capital markets because there are genuine NGOs which are not able to raise funds. So it is either NGO, which is a trust. Understand, from Section 8 company, though it is falling under Companies Act. But NGO, the trust, they can also come to the market, raise funds. So go and read Regulation 292A, say Padlo, 292, that chapter itself is for social stock exchange. So there is an instrument called zero coupon zero principle instrument. It's not called bond. It's called zero coupon zero principle instrument, where it only talks about, as we speak today, minimum of 1 crore is required to be raised by the NGO or Section 8 company. And minimum investment is of 2 lakhs. And only institutional investors are allowed for the time being, because we have to test the waters first. And then maybe it might be thrown open to the retail investors, because already a consultation paper was floated by SEBI sometime in August of this year, saying that should I reduce that issue size of 1 crore to 50 lakhs? And secondly, should I reduce the minimum application size from 2 lakhs to 10,000? That is also on the anvil. You'll get to know very soon, friends, about all this, the impact of the discussion paper as and when the ECB board meeting happens, maybe whenever they take it, you'll get to know about this. So there is a way for raising funds. It has got its own features. One of the element is that it cannot be transferred. It cannot be transferred as of today. As we speak today, it cannot be transferred. It is like you are donating and forget it. Okay. Do I get ATG benefit as of today? No, but yes. As we go, and thirdly, our mindset will immediately not go to ATG, because when we talk about all these things, we'll get into CSR. Whether this will be forming part of the CSR, the answer is no. So this instrument has to test its waters, and that's why this discussion paper was floated. And then maybe when it comes, but be careful, Section 8 and other thing, it's not a simple thing when you file this fundraising document. Again, the projects, you need to satisfy certain essential criteria. It is only for uplifting the poverty ridden or the underprivileged people. You need to showcase that you are doing business, and you need to show your expenditure and the income that you have derived from whether you have done through that is what is one of the first eligibility criteria. First, go and look at whether you fall under those 16 categories which have been mentioned, and whether you fall under the financial parameters which you have mentioned. But don't forget, would there be general eligibility conditions, promoters and everything? If they are debarred and other things, it will not be. So there is a way, Rakesh, and whoever has asked, my dear friend, whoever has asked, there is a way to find out for this. Friends, always, get my number, and always for anything on these kind of things, you can always approach. Yeah, Rakesh.
Yeah, thank you, sir, for throwing light on the funding for Section 8 companies. In fact, we have to see what changes the SEBI will, bring
correct.
to promote this concept. Because this concept is still in evolving stages, and a lot of check and balances are proposed, including the impact assessment to be done by
that's what impact assessment is.
Social auditor. Yeah. Yes, sir. Another question is it possible to pledge the shares just as a security in place of doing the allotment for the first time?
I didn't get this. Can you pledge the shares?
Is it possible to pledge shares just as security in place of allotment at first time of fundraising? I think it is question about collateral security. Just putting your shares before the bank and raise the fund, and not issuing them.
You can do that. And not issuing them.
Yeah.
I don't know. Ajit Sahib, whoever has raised, can talk to me. And, without, because we need to understand slightly more.
Sir,
or is it that even before the IPO, can I pledge the shares of the promoters is what being asked? Or maybe, I don't know. Anyway, Rakesh, go ahead.
Sir, the next question is, why making due diligence, sometimes promoters are very much casual, reluctant in providing all the details. Then how to handle the situation?
So not sometimes, it is always. So that's where, friends, that's where, see, you have two so-called friends like merchant bankers and lawyers with you. Okay. Now that is one thing which you can get a comfort. Second thing is, you can also, you first exhaust all your resources. Without that, don't go and, do that. And let me tell you, the more and more things are being, emphasized or enforced on them, finally, before you file DRHP, things will be in place, friends. I think, because you have to disclose so many things and the promoter cannot shy away with this. They may not be willing to part immediately when we go and talk, but come the day, they will have to. It's, somewhere or other, but don't first exhaust your resource. अभी नहीं मिल रहा है तो public domain में जाके देख लो. Whether उधर से मिल रहा है, ले लो. So exhaust all your things is what I would suggest. Yeah, Rakesh.
Yeah, certainly, sir. So the next question is ECB is a viable option and attractive option as compared to domestic loans?
Definitely on any given day, ECB is definitely a far better option than, but understand, friends, ECB has got its own conditions, right? You cannot bring the money to India, or you can bring it only for some particular projects, all those stuff. Instead of ECB, you should go for FCNR if you have a branch, Indian banks branch outside of India. Those kind of facilities are also easily available. You need to explore that option also. But definitely borrowing from ECB is a better option than what do you call it? इसके लिए, you have this QIPs, right? QIPs. So make a QIP placement and it's an equity share. He has to carry that risk with him. That's also there. Then a lot of other things are also there, right? Green bonds, masala bonds, where, the entire, the fluctuation, the risk of exchange currency fluctuations risk is passed on to the investor rather than to the company. So you have masala bonds and green bonds to take care of all those aspects.
Yes, sir. Thank you very much, sir. We have done with the questions which we have found relevant. And now it's the time to conclude this webinar session of Master Knowledge series. Before we conclude, we extend our heartfelt gratitude to all the participants and our eminent speaker for the day, C.S. B. Ranganathan, sir. Sir, you have covered in detail the various aspects of the fundraising by companies, starting from Section 24 powers to SEBI under the Companies Act, and the way back what has happened in 1970, fairer dilution, and then what role company secretaries need to play in the capital market. Actually, you have more, your session was more inclined what company secretaries should do when they are,
coming
to try their, bit in the capital market. They have to be Mr. Dependable, like Rahul Dravid, as you said. So they should not shy away from the capital market. They should venture into it. And they have to, focus on drafting and the explanatory statement. They should not copy paste what is available in the public domain, because it has to be decided on a case to case basis. And what is the, requirement of that particular situation. And as you have rightly stated that there should be a IPO committee to deal with the situation. We can't go on day-to-day basis to the board for approvals, and also to approve the material threshold by the board instead of, just saying it is, approved in DRHP. So likewise, you have also stated about the role of independent directors, what role they have to play while, they have to recommend during various stages of fundraising, and the confidential filing, new IPO process, and what is the role in preferential issue, what is the role of AIF and the InvITs. So you have covered in details the various aspects of fundraising actually. So we are very thankful to you, sir, for covering this topic in very detail and enlightening all our participants. And I would like to inform that at present we have around 5,000 participants.
Lovely. Thanks, friends. Thanks a lot for
and we thankful to all the participants for placing live and relevant queries and making this session more interactive. Thank you, sir.
Thank you. Thanks once again to the institute, and thanks, Rakesh. Nice to see you. Take care. And thanks. Season's greetings to everyone. Again, let's conclude with that. And all the best to you, friends.
Thank you, sir.
See you. Thank you.